Hello, everyone, and thank you for joining the MVMA and the Minnesota Board of Pharmacy with Dr. Cody Weiberg, discussing recent legislative developments that impact veterinarians. I'm Nicole Cass, the CE Program Manager, and I'm pleased to be your moderator today. If you have any questions during the session, please type them in the Q&A area. I'd like to give a quick introduction to Dr. Cody Weiberg, who received his Doctor of Pharmacy from the University of Minnesota in 1985. He's worked as a clinical pharmacist, community pharmacist, and nursing home consultant. From 1999 until he joined the board in September of 2005, he was the Pharmacy Program Manager for the Minnesota Department of Human Services. Dr. Weiberg is a clinical associate professor for the University of Minnesota's College of Pharmacy and an instructor and course director for the University of Florida Graduate School, from which he received his Master's of Science in Pharmacy Policy and Outcomes in 2009. I'd like to go ahead and turn it over to Dr. Weiberg.
Okay, good afternoon, everyone. I just want to confirm, Nicole, that you can hear me, and if you can, presumably everyone else can.
Yes, I can hear you.
Okay, so what I'm going to do is two things. First, Dan Turnahoy and I exchanged emails. Dan and some representatives of MVMA were at the last board meeting when some issues involving the recent legislation that have an impact on veterinarians was discussed. We didn't do at that meeting what I thought we might do, which is have the board issue a formal interpretation of some of the ambiguous sections of statutes. Our Assistant Attorney General reminded me that in order to do that sort of an interpretation, we'd have to go through an interpretive rulemaking process, which can take a very long time to do. So instead, how this is going to be handled is at the board's next meeting, July 24th, I'm going to ask the board to issue a guidance document, which the board can do without going through a rulemaking process. In the meantime, having heard no objections from the board members during the last meeting, we at the office here, the staff, are going to rely on the interpretations, if you will, or what we believe is the correct way to proceed in some of these ambiguous situations. And so the first thing I'm going to do is go over an email exchange that Dan and I had just within the last week or so, where he expressed what he thought was discussed at the board meeting, and then I supplied a response, because I assume that these are probably the issues that affect veterinarians that are probably having the most questions asked. So I'm going to focus on them first, but then on my phone here, I've got called up on my phone a frequently asked questions document that is on our board's website. And I just did the search term veterinarian. I'm going to go through that after I get done with this first part and talk about any other issue that would potentially affect veterinarians. Now, keep in mind that these are only issues that in some way or the other come under the jurisdiction of the Board of Pharmacy. I really don't know if there were other provisions in other sections of the statute, the agricultural bill or something like that, that might have an impact on various types of veterinarians. So these are only issues where the Board of Pharmacy has some sort of a jurisdiction or some sort of a reason for being aware of these sections of the new statutes. So the first thing I'm going to talk about is the legislature amended the statutes in terms of quantity limits for opiate prescriptions. The legislature last year, or maybe even 2 years ago, did put quantity limits in place when opiates were used for acute dental pain or for refractive surgery like LASIK eye surgery, and that was a 4-day limit. What happened this year is the legislature broadened that limit out. Now the limit applies to any sort of acute pain. It does not apply to chronic pain, and there's some definitions to the statutes of what that means. But this is for acute pain. So this is meant to be post-surgical, perhaps. It is meant to be for an injury, a broken ankle or leg or something like that. It is meant to deal with those sorts of situations. So it's not at this point just dental or refractive surgeries. Like it greatly increases the scope for which the limits apply. Right up until pretty close to the end of the session, I think it would have been easier to interpret the statute, and that's because there was just a 7-day supply for acute pain. There was no mention then or in the final version about veterinary prescriptions at all. They weren't exempted. They weren't specified as being included. But the fact that they weren't exempted under the original language would have meant that limit, in my mind, would clearly have applied. The issue, though, that we had to deal with is the final version of the bill, and for reasons I don't know because I wasn't really consulted about this change, but the final version of the bill amended the language to basically say the opiate limit for acute pain was 7 days for adults and 5 days for minors under the age of 18. And so that introduced the question of how does this or how could it apply to veterinary prescriptions? Unfortunately, one of my dogs recently passed away. He was 17 years old, and he was actually probably, older than most dogs of his breed would have been when they died. He never made it to 18. So, I mean, you obviously can't apply language that talks about minors under the age of 18 to all the different species of animals that are out there. And so that kind of makes it difficult to apply this to veterinary prescriptions. So when I was thinking about this and getting prepared for the last board meeting, I was, there's several different ways I think you could potentially interpret this. But what Dan had said in his email is, and this was his understanding from our meeting, he says, as it relates to the prescription limit, 7 days for veterinary prescriptions, the intent of this legislative provision, now law, was for it to apply to human and not veterinary prescriptions. A guidance document will be developed by the Board of Pharmacy this summer. And my response was, well, that's basically correct. I actually don't know what the intent was, so that's the part that's like, I'm not quite sure what their intent was. There were other provisions in the legislation that pretty clearly indicate that legislators were concerned that people might be using their companion animals to doctor shop, and there have been some very public instances of that occurring. So, for example, one thing I'm going to talk about in a little bit is the legislature made it very clear that when veterinarians are directly dispensing opiates or controlled substance prescriptions, they have to check the ID of the person with some exceptions to that, right? I actually think you could have read the old law to say that veterinarians should have been checking IDs all along, but the legislature chose to make it really clear that this does apply to veterinarians. And so there's indications in the legislation that legislators were concerned about possible veterinary shopping, if you will, on the part of clients. On the other hand, when they did add this language, again, as I mentioned, it's how do you apply under the age of 18 to animals? I don't think you can apply it to that. So, again, my response to Dan went on, we're going to need to get this clarified in the next legislative session. In the meantime, our board will issue a guidance about this at its July meeting based on what I had presented to the board at our last meeting and the fact that none of the board members really objected to what my analysis was. I think it's pretty likely that the guidance is going to point out the difficulty in applying the limits to animals, given that age differential. And I think we're going to suggest that pharmacists still need to use professional judgment in deciding whether to fill opiate prescriptions for acute pain if larger than 7-day quantities are prescribed. But that's not really because of this law. It's because pharmacists have what's called a corresponding responsibility under the Federal the Federal Drug Enforcement Act to do that. And so what the Federal Drug Enforcement Act says is it is the prescriber who has the primary responsibility for making sure that all controlled substances are both prescribed and dispensed for an appropriate medical reason. But the very next sentence says, and pharmacists have a corresponding responsibility. So what we're going to tell pharmacists is, because this law is ambiguous, they're not going to have to consider that veterinary opiate prescriptions are limited to a 7-day supply. They don't have to do that. They can fill prescriptions for a larger quantity than 7 days, but they still have to use their clinical judgment in determining whether the prescription is appropriate. So if they get a prescription and they're talking to the client and they're finding out what this is, and it seems like some relatively minor injury or self-limiting condition, and the prescription is for 90 days, then if they might say, well, wait a minute, I'm not comfortable for filling that prescription for that long. I need to call the veterinarian to see what's going on. On the other hand, if it's 10 days, well, okay, that's over that 7-day limit, but that they can use their judgment at that point. They don't even necessarily have to call the veterinarian. So that was one of the questions that Dan had focused on. The second one is his comments were, as it relates to the new veterinary manufacturer application or renewal fees. So before I go on to the rest of his comments, what I'll say about this generally is that this was the third session that the legislators worked on opiate legislation, which was designed in some way to raise revenues, first from opiate manufacturers. That was all of the first session. The focus was entirely on opiate manufacturers. It was entirely on opiate manufacturers until late in the 2018 session, in which case wholesalers got brought into the equation. And then this year, it changed quite a bit. The original version of, not version, there were many versions of this bill, but the versions of these bills up until this year were all designed to collect a fee from either opiate manufacturers or wholesalers based on the volume of opiates that they shipped into the state. So the larger number of units that a particular manufacturer or wholesaler shipped into the state, if you will, the larger their fee would be. What changed this year is that the decision was made to still have a little bit of that. There's still what's going to be called an opiate product registration fee. And based on our analysis, about 15 manufacturers out of the 87 opiate manufacturers we're aware of are going to have to pay that fee. It's $250,000, and that fee is going to be applied to any manufacturer who has opiate products sold in the state in a quantity greater than 2 million units. I don't believe any veterinary opiate manufacturers sell that many units in the state, and I don't think any of them were in that list of 15 manufacturers that we identified. So that's not going to apply to them. But what changed is the bulk of the revenue is now not coming from that product fee. It's coming from pretty steep increases in this board's licensing fees for most of the businesses that we license. So prior to the passage of this legislation, we used all of our licensing fees, both from pharmacists and the businesses we license, to fund our operations. Now, and by the way, for the businesses we licensed, Those fees ranged from $110 for medical gas distributors to $235 for full-blown FDA-registered manufacturers. So what's happened is, except for pharmacies, which the legislature for some reason wanted to keep out of this process, and except for this new type of entity we're just starting to license called a third-party logistics provider, all other businesses that we license, and that would include manufacturers, wholesalers, medical gas distributors, medical gas manufacturers, all of these entities, their licensing fee is going to go up to either $5,260, with $5,000 going to other state agencies to deal with the opioid abuse epidemic, or in the case of opiate manufacturers, it's going to go up to $55,260. And the $55,000 goes to the other agencies. The remaining amount goes to us for our operations, just like it always has. It's that last thing that brings up a question in the veterinary world, because veterinary opiate manufacturers were quite concerned about that $55,260 fee. And they, from what I've read in some email exchanges that were forwarded to me, they're either one of two things they think could happen. One is that the cost of the products could go up, which means the cost to veterinarians to purchase the products could go up, and ultimately that's passed on to the clients. Or the possibility that maybe for some of the smaller companies, they just wouldn't do business in the state of Minnesota anymore. And one of the email exchanges I read was, certainly talked about Minnesota because we just did this, but also mentioned that New York State had tried to do this last year, although they were sued successfully, and they haven't put their program into place. But I think there's also a concern among the veterinary opiate manufacturers, and this is probably a concern, frankly, among all manufacturers and all wholesalers, is it's not just Minnesota. It's if Minnesota does this and does it successfully, what do the other 49 states do? And if all of the states start imposing fees, then what impact will that have? So at any rate, one of the reasons that this came up for review at our board meeting, though, is it wasn't so much the concern that the veterinary opiate manufacturers might have. We're always trying to focus on concerns anyone has for the statutes that we enforce. But, if the legislature clearly tells us to do something, then we do have to, enforce the law as it's written. But this is another area where there's some ambiguity in the way that it was written. And so Dan's continuing comments were, the Board of Pharmacy believes that this provision is clearer than the last one, that veterinary drug manufacturers would be subject only to the increased fee to $5,260 and not the $55,260 fee. Opioid drugs that do not fall into the veterinary non-legend or legend drug category would be subject to that higher fee, and there won't be a guidance document for this. So that again, that's all what he said is all basically correct. I think that when you take a look at the way this particular part of the law is written, it's maybe ambiguous enough so that someone who doesn't do a lot of interpretations of the statutes might think it's a bit ambiguous, but I actually think it's fairly clear as someone who actually drafts legislation and has spent 20 years interpreting it. I think the way that this is written, whether it was a legislative intent or not, the way that it was written is such that all manufacturers, all wholesalers are going to have to pay a $5,260 fee. But the way that they wrote the language about opiate manufacturers being subject to a $55,260 fee, the way that they did that, I think the only way to really correctly interpret it is that implies only to manufacturers that make human opiate products. And so if there is a veterinary manufacturer and it produces only opiate products used in veterinary practice, it is only going to be subject to the $5,260 fee. If that manufacturer happens to also make human opiate products, it's going to be subject to the $55,260 fee. And another somewhat related issue, a third issue, applies to the licensing fees that manufacturers that have multiple facilities, what they need to pay for those various facilities. So the way that the licensing law reads for manufacturers, and for wholesalers actually, but for manufacturers, the long existing law says that we don't license per company. We don't license a corporation, we license facilities. So what the law has long said is that each facility, each manufacturing facility within the state of Minnesota, or each facility outside of the state of Minnesota that ships product into the state, each of those facilities needs to be separately licensed. So what the legislature did when it created that $55,260 opiate manufacturer registration fee, the language still says each of those facilities has to be licensed, but then there's new language that says, but manufacturers of opiates, they only have to pay the $55,260 fee for one facility. And so the question here became, what then do we do in various circumstances? So, for example, first of all, I should say this as background, there are actually very few manufacturers that have more than one facility licensed. Most of them actually only have one facility licensed by us. But there are some that have 2, 3, maybe 4 facilities licensed. And so there's a couple possibilities. So one possibility is every single facility that's licensed by us, every single one is used to produce opiate products. Another possibility is facility A is used to produce opiate products, but facility B isn't. And so the question becomes, what sort of licensing fee applies? And I think the correct way to interpret this is that if you have an opiate manufacturer, and let's say that it has 3 facilities, and all 3 of those facilities are used to produce opiates, and products from all 3 of those facilities are shipped into the state, I think that we're going to have to work, my staff is going to have to work with them and define which of the facilities they want to pay that fee. And all 3 will need to be licensed by us, but we're only going to be able to charge one $55,260 fee for one facility. The other 2 facilities aren't going to pay a fee, even though they have to be licensed. But let's say the company has 2 facilities that are used to produce opiates, and the 3rd facility doesn't produce opiates. In that case, one of the 2 facilities pays a $55,260 fee. The 3rd one that produces no opiates pays a $5,260 fee. And so again, the only impact that this might maybe have on veterinarians is the response of veterinary manufacturers to those increased fees, and whether or not, if the fee increases get high enough, they decide not to do business with accounts in the state. We're hoping that doesn't happen. One way that it might make a difference is if they have to pay that $55,260 fee, the minimum number of times they have to pay. If they had to pay that for every single facility and suddenly their licensing fees were up in the $200,000 range, there might be some concern, but I'm hoping that the way that we're looking at this law will minimize the chance that they will want to stop providing products in the state. Let's see. And then there were some other items. So those three items were actually addressed at the board meeting because there was at least a little bit of ambiguity with them. But there were other items not covered at that board meeting, but that still go into effect July 1st. And so the first thing is something I already mentioned, and that is as it relates to veterinary dispensing of controlled substance prescriptions, and that is and again, this is what Dan is writing, his understanding is veterinarians are required to check a photo ID of the person purchasing the controlled substance. Although a photocopy of the ID is not required, it's recommended that the veterinarian note in the patient record that they check the photo ID before dispensing the drug, and so forth. So here's my comment on this. Again, it's very clear now, clearer than it was, that veterinarians are going to have to check the ID of the person purchasing the controlled substance, and this is not just opiate, this is any controlled substance. But here's the thing. First of all, there's an exception in there that's been in there all along, which says if the person who is purchasing the product is well known to you, you do not have to check the ID. So if you have a client that you come in, you trust that client, they've been bringing their animal into you for years, and you're going to dispense a controlled substance, you do not have to check the ID. So that's one exception. In regards to the questions that are coming up, the language here reads that you have to check a valid photographic ID. It does not say that you have to make a copy of that ID. And I think most commonly this is going to be a driver's license, but it does not have to be a driver's license. It does not, for example, say that it has to be a valid government-issued photographic ID. And so I can just think of some other things that could work. So a college or university ID that has a photo in it. Certainly a driver's license, which is government-issued, or the government-issued identification cards for people that drive, those would work. Passports are government-issued too, of course, but a passport could work. Even a employee identification ID, maybe from a manufacturing plant where they're given an ID that has a photo in it and indicates their name. So there are various things that you can check. And again, no requirement to make a copy of that ID and keep it on record. There's actually no requirement even to keep a log of checking the ID like there is for pseudoephedrine sales in a pharmacy. It's going to be up to the Board of Veterinary Medicine, I think, to decide how it wants veterinarians to handle this process. So what we at the Board of Pharmacy, though, are telling pharmacies is, yes, there's no requirement for you to make a copy of the photo ID, and we actually don't necessarily want you to do that. And there's no requirement to notate anywhere in the records or keep a log that you check the photo ID. But we are telling them that, our board at least, has gotten complaints from a number of complaints over the years that I've been here from people who say that when they went in to pick up their controlled substance prescription, somebody else had already picked it up without their permission. And a lot of times we can't track down who that was. Sometimes it was the person's neighbor who they happened to tell them they had to go pick up a prescription, actually beat them to the pharmacy. Now, something like that is maybe not going to happen at all in your world because you may not be even dispensing this unless the client and the animal are right there. But in pharmacies, in my house, I'm so busy that my wife picks up all of my prescriptions, not me. And so we're telling pharmacies that because we've gotten those complaints, you might want to log this because if we do get a complaint that that's happened and we go to investigate it, you would have proof that you checked the ID. But again, there's no requirement to make a copy of that photo ID, no requirement to keep a log that you have done it. But there is a requirement that if you don't know the person, that person's not well known to you, you do have to check a valid photographic ID. Another issue that came up is we talked a little bit about quantity limits on prescriptions, but there's also now a time limit for opiate prescriptions in terms of when they can be filled. Basically, no prescription for a Schedule 2 through 4 opiate pain reliever can initially be dispensed more than 30 days after the date of issue. So this, again, if you are dispensing this yourself, as you can do as a veterinarian, then it's probably not much of an issue because you're probably going to do it right when the client is in there with the animal. But if you do issue a prescription for something like, say, tramadol, that the client is going to bring to a pharmacy, what you might want to let them know, and what we're hoping all prescribers will let their patients know, is this is only valid for 30 days. If you don't get this prescription filled within 30 days and you bring it to a pharmacy, it's not going to be valid anymore. The other thing is, and I don't know how common this is in the veterinary world, but if you write a prescription like that and you give refills, the first fill has to be filled within 30 days, and every subsequent refill has to be filled within 30 days of the last fill date. And so, that's going to be on the book as well. Another issue that we finally got addressed, we've been working with the MVMA on this for at least a couple years, and that is we became aware at the Board of Pharmacy of certain financial arrangements between veterinarians and pharmacies that we think pretty clearly violated a law in the Pharmacy Practice Act, at least, about fee splitting. And this is regardless of how entities tried to set this up, and there were entities that tried to set this up in a way that they said, no, this isn't violating fee splitting. We really didn't think that any way that this was ever set up was not a violation of our fee splitting statutes. So what we worked out with the MVMA was language that allows this to continue as long as certain notifications are made. So there are two basic reasons that an agency like ours would be concerned about fee splitting. The primary one is that the patient, or in this case the client, is going to actually ultimately pay a lot more than they would have to pay if they just took a prescription directly to a pharmacy. That's the primary thing. And related to that is, we believe that the public, we're mostly about patient safety, but we also believe that the public has the right to fully understand what their money is going for and what they are paying for. And so the agreement that we reached basically says, and this is in one of those FAQs that's in our FAQ document on our website, the question is, can pharmacies enter into arrangements with veterinarians through which the prescriber can be involved in setting the price that the patient will pay for the dispensed drug product? The answer to that now, because of this change in law, is yes. Veterinarians are actually the only type of prescriber that can do that now, because we also clarified the law to make it crystal clear that no other practitioner can do this. But a veterinarian and a pharmacy may enter into such an arrangement provided that the client or other person paying for the prescription drug is notified in writing with each prescription dispensed about the arrangement. So that means a notification on either the veterinarian or pharmacy's website that there is some sort of an arrangement is not enough. There's going to have to be something in writing given by the pharmacy each time the prescription is dispensed that says there is a financial arrangement with the veterinarian. And let's see. The notification does not have to explain that individual financial transaction. That was kind of the last compromise we worked out. So the notification does not have to say, for this prescription, your total cost is $50, and the pharmacy is getting $25, and the veterinarian is getting $25. It simply has to say there is a financial arrangement between our pharmacy and your veterinarian in regards to this prescription. And I'm going to wait to answer the questions, and I'm almost, I think, done here, and I'll answer the questions that pop up then. So there is another situation which, again, I'm not sure how common this would even be, but one of the issues that pharmacies have had to deal with for a very long time, because of the way our state law is written, is what to do, let's say on a Sunday afternoon, when somebody comes in with someone comes into the pharmacy wanting a refill of a medication that's for a very serious disorder, a seizure disorder, or they're insulin-dependent diabetic, or anything you can think of where if they go out, if the patient goes without that prescription, even for a short period of time, there can be dramatically bad adverse events happening, right? And so what our board has done for literally decades is exercise enforcement discretion. So basically what the law, up until now, what the law said is a pharmacist had to have a refill before issuing a refill, right? If the refills ran out, then technically, the way the law has been written for decades, the pharmacist couldn't give out a single tablet. But what we have told pharmacists for decades is, well, that's true. Technically, you can't do that. That's the way the law reads. But you have to take care of the patient, too. So if you have a patient that comes into your pharmacy on Sunday afternoon and you know that they have a seizure disorder that's been very difficult for them to control, it's finally under control, they're completely out of the medication, we are going to exercise enforcement discretion, and we're not going to discipline you for giving them a 5-day supply. Well, you get a hold of the prescriber to get more refills. And that worked pretty well for a long time. But I think what's changing is that one of the things that's changing is that for certain drugs, first of all, this part hasn't changed. These drugs have been this way a long time. If someone is diabetic and comes in and it's insulin that they don't have, you can't just dispense a 3 or 4 or 5 day supply. You have to dispense a whole vial. And that vial, depending on the dosage, could last the person a month. And in the past, pharmacies would even do that, and we were okay with that. But two things have happened. First of all, when you're talking about a drug like insulin, the price has skyrocketed. So one vial now can be worth $500 or $300 or something like that. And that's combined with the fact that pharmacy benefit managers have been more aggressively auditing pharmacists and taking back the money when they haven't followed the exact letter of the law. So I think what's been happening is pharmacies are thinking to themselves, if I dispense this very expensive drug and I bill the patient's insurance, their PBM, and I give them this $300 bottle, I could very well come back and have all that money taken away. And so they've been reluctant to dispense drugs like we've told them they could. So what this new law does is it says that in certain circumstances, if a person comes in and they have been regularly filling the prescription drug at that pharmacy and they simply are out of refills, it's a drug that is used to treat a very serious condition, and the condition is such that if the patient goes without the drug, they're going to suffer severe adverse consequences. If all those conditions apply, the pharmacist can dispense up to a 30-day supply, and the insurance company has to pay for it. Now, the pharmacist also has had to have made reasonable efforts to contact the prescriber to get more refills, and they have to notify the prescriber within 72 hours of dispensing the emergency supply. And then if they cannot get additional refills, like, for example, the prescriber says, well, no, I actually want to see that patient back in my clinic, then they have to notify the patient that they really need to get back in the clinic. So again, I'm not sure how often it's going to occur that a veterinarian is going to write instead of directly dispensing a drug that's used for chronic conditions, that you're going to write a prescription, it's going to be for a 30-day supply and have multiple refills. But there's no exception here for veterinary prescriptions. So it's possible, and so we're telling you as we're telling other prescribers, it's going to be possible going forward that a pharmacy will be contacting you and saying, well, this was an emergency situation covered by the law. We went ahead and gave the client a 30-day supply. Now can we get additional refills from you? Another issue that we're going to talk about is, and many of you, if you use compounded products, you probably are already aware of some of the background here. But Minnesota state law is such that the practice of compounding a drug by a pharmacy compounding a drug that's not meant for a very specific patient at the time it's compounded, just compounding like a bulk supply of a drug and selling it to a practitioner for office use, that's actually been illegal in this state for a long time. And that compounding disaster that we had 5 or 6 years ago brought all of this into focus. And so we were reminding people, including pharmacies that did compounded for veterinary office use, that this has always been a violation of state law, and it's even a more clear violation because of changes we made after that compounding crisis. But, however, what ended up happening is that, just a second here, I'm getting a notice here. Okay, actually, well, let me do that. Okay, sorry, my computer just dinged at me and put a notice up on the screen. So anyway, MVMA came to us and basically convinced me that they had a really legitimate concern here, which is that because there are obviously a variety of species that are treated in a veterinary office, and the way I've been characterizing it is veterinarians may have to, even within a particular species, might have to treat anywhere from a 2-pound teacup Chihuahua to 120-pound, I don't know, Grand Mastiff or whatever they're called. That they're simply, for certain drugs that were needed in an urgent or emergency situation, there weren't enough commercially available products to handle all those situations, and it was vital to have pharmacy compounded office supplies of certain drugs. So what the board did quite some time ago now is we issued a guidance document that indicated that just like the FDA was doing, we would exercise enforcement discretion and allow pharmacies to compound products that they could then sell at wholesale to veterinarians that could be used either in the office when, like maybe some antidote or something had to be given immediately, or even dispensed. And ultimately, we changed the amount that could be dispensed, so it's now up to 10 days. So something that maybe you give the first dose in the office, but then you have to send additional doses home with the client to keep treating the animal. We basically issued a guidance document saying, well, yep, this actually what we're about to allow you to do is technically illegal, but we recognize the problem, and until we can get it fixed with the legislature, we're not going to take any action against pharmacies who do that sort of compounding as long as they do these certain things and don't do these certain things. And so that guidance has been in place, still is in place until July 1st. But what we did is we basically just took that guidance document and we incorporated it into the statutes. So as of July 1st, there's no more need to rely on the guidance document. It's now a matter of law that this can be done. And I'm going to take a quick look, like I said, at my FAQ document, but I think I've covered a lot of things. Well, one thing is you may or may not have heard that the legislature passed legislation to require certain types of prescribers to complete continuing education on appropriate prescribing of opiates and appropriate pain management. That does not apply to veterinarians. So, but you may have heard through the grapevine, oh, I'm going to have to do CE now on appropriate prescribing. of opiates and appropriate pain relief. That does apply, but that applies to physicians, physician assistants, nurse practitioners, not to veterinarians. And this is probably going to be rare, but pharmacists were granted additional authority to actually administer a wider variety of drugs. Up until this law goes into effect on July 1st, really pharmacists were limited in administering drugs to emergencies and first doses, and then they can provide vaccinations. Going forward, and this is why I don't really think it's going to apply in the veterinary world, they're now going to be able to administer injectable drugs that are used for alcohol and chemical dependency and for mental health disorders. So I don't think that's going to apply. You again may or may not have heard, pharmacists have been able to do what's called generic substitution for 30 years. And what generic substitution means is, so let's say that in Lipitor, a drug almost everyone knows about, for high cholesterol, a statin, that's available generically. You have both the brand name and you have an identical, a variety now of identical generic products. And so it's the same drug, same dose, that sort of thing. That's generic substitution. What was passed was something called therapeutic substitution. That would be, using Lipitor as an example again, if a pharmacist could potentially do therapeutic substitution if they decided, you know what, instead of Lipitor, I think Zocor. Instead of atorvastatin, I think simvastatin will work just as well. So now you have a different chemical entity. That's called therapeutic substitution. Well, the way that this language was written is, if you just looked at it at first glance, you would think that, oh, well, pharmacists can now do therapeutic substitution. But in fact, nothing has changed compared to existing law, because it says that that can only be done if the pharmacist has a protocol with the prescriber not a prescriber. When they do vaccinations, they have a protocol with a single Minnesota licensed physician that allows them to do vaccinations for any patient that walks in, whether that patient sees the physician with whom they have the protocol. This says they can do therapeutic substitution only if they have a protocol with the prescriber. That literally means if a pharmacy, I used to work in Red Wing. We had people come in from Mayo Clinic. We had people come in from clinics up in the Twin Cities. We would literally have had to have a protocol in place with every single prescriber, and that's just not practical. So I don't think you're going to have to worry about, if this would even be a concern, you're not going to have to worry about any pharmacist making a substitution that you don't want them to make in that manner. We talked about veterinary compounding for office use. And let's just keep going on here. We talked about the financial arrangements at length. And that is really it. I think that's a summary of all of the legislation that is somehow under the jurisdiction of the Board of Pharmacy that somehow also has an impact on veterinarians. And I think, let's go to the question here from, looks like Kristen. With our client charts, we typically only have one or two names directly on the file. Would it have to match the name on the chart? Would you just document in the chart who picked it up? Again, the documentation piece, I think, is going to be something that the Board of Veterinary Medical Practice is going to have to give you some guidance on what sort of documentation that they might want to see. The law itself doesn't require you to document anything. If you're going to document it, what we're going to tell pharmacies, we're going to recommend that they document it, even if the law doesn't require it. We're going to recommend they keep a log, because pharmacies don't really have like written charts, and they could potentially put it in the record in the computer, but in pharmacies, it's going to be easier for the technician who's waiting on the patient to just check the ID at that point, because it doesn't have to be the pharmacist himself or herself that does it. So it's going to be easier in the pharmacy world for the technician to check the ID and then just jot something down on a chart, that, maybe the prescription was for Cody Weiberg, but jot down ID check for Kathy Weiberg. All right, let's see here.
Dr. Weiberg, would it be easier if I read those for you?
Sure, let's see. Well, I have... You can go ahead, yeah, because otherwise I'm kind of having to scroll through it, and it's kind of...
Sure.
Yeah, go ahead.
Staying on that same topic with checking IDs,
Yeah.
do they need to check ID for acute pain, 7-day or less prescription, opioid prescriptions, post-surgical, for example, or just for chronic pain management?
It is any. It's not even just opiates. I think well, let me just go back and take a quick look. I actually think it applies to, unless they changed that too. Maybe they did change it to just opiate prescriptions. This used to apply to all controlled substance prescriptions, not just opiates. But I'm going to go back and take a real quick look here. Make sure that I'm not giving misinformation here. Okay, let's take a look here. Just about there. No, I'm right. This doesn't apply just to opiates. That's the first point to make. It applies to all Schedule 2 through 5 controlled substance prescriptions. There is no limitations on whether it's obviously for acute pain or an acute condition of any sort. It is any controlled substance prescription that is dispensed for any reason. You have to check the ID.
Okay, thank you. Switching gears, I have a couple questions about fee splitting. Does the requirement about pharmacies and vet fees apply to the online pharmacy that a clinic works with and gets a revenue from?
Yeah, it does.
Great. And the next question is very similar. We have an online pharmacy through VetSource. Will the new laws regarding fee splitting apply?
Yes, it will.
Thank you. Does anyone else have any other questions? You can type them in the Q&A section. Give you just a moment to do that. In the meantime, Dr. Weiberg, thank you so much for your time, and for everybody who's attending online, thank you for joining us. We had a great crowd today, considering you basically only got a week's notice that we were putting this together.
There's another question under the tab My Q&A from Nancy Hansen. It says, where does gabapentin fit into this? Gabapentin is not scheduled. Gabapentin dispensing by pharmacies has to be reported to the Minnesota Prescription Monitoring Program, but it is not scheduled in this state. We were actually recommending to the legislature that they consider scheduling it, but they didn't want to do this at this point. Other states are doing it. It is being increasingly abused, either by itself or it is at times being abused in conjunction with methamphetamine, because people who abuse methamphetamine find that if they also take gabapentin, they can still get the desirable high they want from the methamphetamine, but some of the adverse consequences of taking methamphetamine are muted or mitigated with gabapentin. So it is becoming increasingly a problem. More states are scheduling it. The DEA is considering scheduling it, but it is not scheduled. And so the requirement to check an ID doesn't apply, and it's sometimes used for pain, but it's not an opiate. So none of the opiate prescription limitations, none of that applies.
Thank you. That was not showing up on my end, so I'm glad you caught that. Going back to a question with documentation for describing the fee splitting from VetSource, do they need to provide that information to the client?
Not the veterinarians. It is the pharmacy that needs to provide it with each prescription. So if it's an out-of-state online pharmacy, they're probably going to have to print something up and include it in the materials that they send the patient. But veterinarians do not have to do the reporting, or not the reporting, the notification. It's the pharmacies that have to do the notification.
Thank you for that clarification.
Another question, phenylpropanolamine, that there's nothing about phenylpropanolamine. That's not scheduled either. I'm a little bit worried that my computer might cut out on me in 30 seconds. It says it's going to automatically restart.
Okay. Well, I'm actually not seeing any other questions, so if we do happen to lose you, thank you again for joining us today. Yeah. Greatly appreciate it. For everyone who's still online, just a reminder that once I've documented that you attended, I will send you a link to complete the evaluation and your CE certificate. Thanks, everybody, and have a great weekend.
Thank you for inviting me. Bye-bye.
Bye.